Every week, I'm going to take you through some top legal developments that hit headlines. If that means something, the idea is to break down legalese in simple words, however much it's possible, and to democratize the courts through legal journalism. This is a curated list of those legal developments which are of significant public importance and interest. Under scanner this week are 3 developments. Number 1. Chief Minister's promise legally enforceable. Number 2. Kerala government faces heat in Supreme Court for Bakrid relaxations amid rising infections. Number 3. Victims of post-poll violence in West Bengal have no faith, no trust in the state government. The Delhi High Court has held on Thursday that it is impermissible for the Chief Minister to run away from his obligations if he has put forth promises and assurances to the people. Now, what happened was 4 daily wage labourers approached the High Court in their capacity of tenants, seeking some action from the Arvind Kejriwal-led government to realise the promises that its head representative, Mr. Kejriwal, had made before the public in a press conference on March 29, 2020. The Chief Minister of Delhi had then requested all landlords to postpone the demand and collection of rent from those tenants who are poverty-stricken. In furtherance of this request, he made a clear promise that if any such tenant is unable to pay rent, the government would pay the same on their behalf. So this is the context in which the 4 petitioners told court that the Chief Minister has failed to deliver on the said assurance and that the court must direct the government to deliver what the Chief Minister had promised. The daily wage labourers also told court that despite their repeated requests, the Delhi government turned a blind eye towards their plight, even though the CM himself made such humongous promises directly to the people. They added that when they made a representation before the CM's office asking to adhere to the promises and pay their outstanding rent, the office of the Principal Secretary of GNCTD replied with an email that their request is being forwarded to the CM's official email ID. This was clearly a mocking of the plight of the aggrieved, they said. So what did the court say? The single judge bench of Justice Pratibha M. Singh, while relying upon a UK judgment, R versus Liverpool Corporation, ex-parte Liverpool Taxi Fleet Operators Association, concluded 2 folds of principles regarding the present issue. Court observed that both doctrine of legitimate expectation and promissory estoppel are not absolute in nature and that there are various conditions required for enforcement of the claims under it. Justice Singh noted that the above-mentioned doctrines are a reflection of legal recognition being accorded to the trust that citizens repose on promises, assurances, representations which are made by constitutional functionaries and governmental authorities, and that the authorities are answerable to the people for the same. In this light, court said that many tenants of Delhi, on the currently unenforced assurance of Mr. Kejriwal, must have altered their position on leaving Delhi after the announcement of the lockdown in March 2020. Therefore, the CM is responsible for the people who trusted his words of assurance. So now what? Court issued directions to the Delhi government to take a decision as to the implementation of the same within a period of 6 months, bearing in mind the larger interests of the persons to whom the benefits were intended to be extended towards the said statement of the Chief Minister. Government has been further directed to form a clear policy upon the decision taken. The Kerala government faced heat by the Supreme Court on Tuesday for its decision to declare lockdown relaxations for the festival of Bakrid. Court said that this decision of the Pinarayi government was antithetical to Article 21 of the Constitution. On July 17, the Kerala government had relaxed COVID norms in the state for 3 days preceding Bakrid, even though the infections continue to rise in the state. Mind you, as on July 21st, fresh COVID infections in the state of Kerala stood at 17,481, accounting for 42% of India's total COVID tally. We will take stern action and hold you responsible in case of spread of the pandemic as a result of such a relaxation, the bench of Justices R.F. Nariman and B.R. Gawai said. Even though the Kerala government tried to justify its relaxations to court by saying that the same was required to allay the traders and give them some respite, court said that an assurance for traders or anything more does not inspire any confidence from the people of India or this court, and that the Pinarayi government's affidavit disclosed a sorry state of affairs, disregarding the health of all citizens under Article 21. The plea was filed by a Delhi resident who argued that despite court's discontentment over the decision of the state of Uttar Pradesh to conduct Kanwar Yatra, Kerala government is acting in a casual manner by relaxing the COVID norms. It is pertinent to note that though top court slammed the Kerala government for its decision to declare lockdown relaxations for the festival of Bakrid, it did not set aside the notification of the Kerala government, but instead directed it to follow what the court had earlier directed in the Kanwar Yatra matter. Victims of post-poll violence in West Bengal informed the Calcutta High Court on Thursday that they neither had any faith nor any trust in the state government, so far as their complaints of violence against goons, allegedly from the ruling party, the Trinamool Congress, is concerned, and that an independent probe should be conducted to look into the cases. The NHRC's report has been taken on record by the court, and some glaring failures of the Mamata Banerjee-led government have come on record, depicting complete anarchy and retributive violence against BJP workers. The report has been gone on to state that the state does not function under the rule of law, but on the law of the ruler, that is, law of Mamata Banerjee. So what ensued in court? Senior advocate Abhishek Manu Singhvi said that in light of some observations made by the NHRC in the report against the state government, it is pertinent that the government be allowed to file a reply before court and that principles of natural justice dictate the request be allowed. He also added that since a redacted copy of the report had been provided, he may be supplied the complete and relevant annexure. Senior advocate Mahesh Jetmalani strongly objected to this demand and added that the state was in fact now in no position to demand findings of the NHRC, considering that it was their inaction and apathy which had led to the present litigations in the first place. He strongly raised the argument for an independent probe, adding that the state of West Bengal's earlier conduct had made it disqualified from handling the complaints concerning the West Bengal post-poll violence. Advocate Chesai Deepak said that the victims of post-poll violence have been suffering for months and that incidents of violence continue to be reported, including those of sexual assault. He also added that a man was recently found hung by a tree. We do not trust the state government or its machinery owing to their dereliction of duty in the past, he said. So what next? Court said that as a last opportunity, the state of West Bengal may file a reply by the 26th of July. Singhvi insisted that some more time may be given, but the court refused to grant more time. Court rejected the request of the government to get a copy of the Annexure 1 of the report, stating that the same had personal details of the sexual assault victims. That's all for this week. Don't forget to subscribe to our YouTube channel for more insightful content and interesting events. See you later.